Hi, everyone. I would like to welcome you on behalf of the Elder Law Section to our Laws Over Lunch webinar series. On behalf of the Elder Law Section's Estate Planning and Ethics Committee, we have Heidi Brown, Cassandra Julinskik, Heather Samuels, and Max Solomon presenting on Ethics, Estate Planning, and Suspension, a Cautionary Tale. The course number is 7657, and the PowerPoint will be emailed out this afternoon to everyone that has registered. Now, I'd like to introduce our speakers. Heidi is an associate with Oster and McKinney, PA, who is board certified in elder law by the Florida Bar. She's a member of the National Academy of Elder Law Attorneys, Academy of Florida Elder Law Attorneys, the Elder Law Section, and Real Property, Probate and Trust Law Section of the Florida Bar, and the Estate Planning Council for Lee County. Currently, she is the chair of the Estate Planning Committee of the Elder Law Section. Cassandra is a partner in the West Palm Beach office of Schutz & Bowen, LLP, where she is a member of the Private Client Services Practice Group. Cassandra has been named in Florida Super Lawyers Magazine as a rising star in estate and trust litigation. She is a member of the Real Property Probate Trust Law section of the Florida Bar and the Elder Law section of the Florida Bar, where she is currently serving as vice chair of the Ethics Committee. Cassandra earned her bachelor's degree from the University of Florida. She earned her law degree and graduate degree in a comparative law from Louisiana State University. Heather is a Florida Bar board certified specialist in elder law, and she graduated cum laude and within the top 20% of her class at Nova Southeastern University's Broad Law Center. She is the chair of the Elder Law Section. She is a co-chair of the Elder Law Section's Florida Bar Ethics Committee and a member of the Executive Council of the Elder Law Section. Heather was honored by the Elder Law Section as Member of the Year for her work as co-editor of the Elder Law Advocate in 2020. Max is a proud triple Knoll, having received his Juris Doctorate, Masters of Science, and Bachelor's in History and International Affairs from Florida State University. He has been nominated by his peers as a rising star in Florida elder law in 2021, 2022, 2023, and holds various leadership positions in the elder law section of the Florida Bar, including the current chair of the membership committee and vice chair of the estate planning committee. He was recently won an award from the section for his outstanding contributions to the elder law section. Thank you guys so much for being here, and I'm going to turn it over to Heidi.
Good afternoon. Today, we're going to talk about ethics, estate planning, and suspension. But more specifically, we're going to talk about first, we're going to use a real life example of a recent Florida Bar suspension of an estate planning attorney. Then we're going to talk about ethics in estate planning in general. We'll talk about conflicts of interest and self-dealing ethics rules. And then finally, we will talk about the best practices in estate planning, for example, fee agreements, disclosures, and serving in multiple capacities. All of this will have the backdrop of estate planning attorneys who draft documents and also name themselves to be fiduciaries in those documents. So now Max will talk to us about membership in the elder law section.
Thanks, Heidi, and thank you for everyone giving up their 1 hour of lunch to join us today, talking about such an important topic. But before we continue, I want to talk about another important topic about all of the amazing opportunities that membership in the elder law section of the Florida Bar provides all of us. And we're only going to talk about just a few of the many, many important and key ones that the four of us thought were extra important to us in our careers and our very, very different journeys of how we got here to become speakers and talking about this important subject that we thought was near and dear to our hearts today. So as membership chair, I just wanted to talk about a few things that people really probably didn't think about or really don't know about the sections of the Florida Bar and how they can join. So coming up, we're going to have a lot of new lawyers in the Florida Bar, and many of them are on this call. And I just wanted to say you're almost there, and congratulations. And once you get that ticket, I just want to remind you that upon passing the bar exam, you can join 3 sections for free. And I hope that the elder law section is one of them. And the elder law section offers affiliate members, and one of that affiliate status is to law students. Law students can, during their time in law school, join the elder law section for free. So I hope that all of the law students on the call join the elder law section for free right after they get off this CLE today. But the elder law section offers a lot of different education opportunities in addition to this important ethics CLE today. And I'd like to turn it over to Heidi to talk about the CLE opportunities that we have.
Thank you, Max. Some of those CLE opportunities that we have are that every year we have what's called the annual Elder Law Update and Essentials. And it is a 3-day CLE where you can get all of your CLE credit in one fell swoop. And it's usually held in either January or February. This year we've changed it so it'll be in February so that it won't coincide with the Heckerling Institute. But in this one annual review, you can get all of your CLE credits. We also have a really neat CLE program that all of you already know about, and that is the Law Over Lunch, or LOL series. This is a brand new series that we've just started a couple of months ago. And every month we're going to have a 1-hour CLE where we can delve into a specific topic and really give it a good workout. And these will be very narrowly tailored issues.
Well, thank you, Heidi. And in addition to our actual CLEs that our committees put on, we'll talk more about our committees in a little bit. Our committees also work together to help publish our newsletter and publication called The Advocate. And we have one of our prior editors of The Advocate happens to also be one of the presenters today. So I'm going to turn that over to Heather to talk more about The Advocate.
Okay, thank you, Max. So the Elder Law Advocate is the publication of the Elder Law section of the Florida Bar. As Max said, most committees contribute articles to the publication, which is published 3 or 4 times a year, depending on the year and the content. And what's great about the Advocate is that it is very accessible. The articles are short, easy to read and understand, and you can get through the whole thing in 20 to 30 minutes and really learn what's going on with the elder law section of the Florida Bar, from hearing from our lobbyists about the latest going on in the legislature, to hearing from our chair of our section about different projects that the elder law section has going on, to various committees speaking about and writing about really what they have going on in their committees, such as new legislation, such as concerns that have come up. And it's really a very informative publication. I encourage all section members to read it, and it's something that is a really special part of our section because it's so accessible to members of every level. So definitely one of the major membership benefits of the elder law section, I think, is the Advocate, because you know what's going on all the time when you read it.
And it's also fantastic for law students and younger attorneys to workshop future law review articles. And I also wanted to talk briefly about all the networking opportunities that we have, both at our in-person conferences, online, offered through different different media, especially in our post-COVID world, through our mentorship programs, through our committee systems. We connect attorneys and law students, and that as we move forward, one of the most important and amazing programs and one of the most important and meaningful opportunities that the elder law section provides all of us, and speaking personally, is the community. Through our new listserv programs that we're rolling out this year, we're able to connect and discuss very intricate topics with other like-minded attorneys, judges, both at the county level, throughout the state. And that's just provided a lot of different opportunities for us. Additionally, elder law is a board certification topic area, and the section provides a lot of resources through the annual update to help study and different resources to help get you ready for the board certification exam. So in the actual link is a membership application. Again, there are different types of memberships. So if you represent guardians, professional guardians, they can qualify as an affiliate member. You do not actually need to be just an attorney. Your professional guardians can join and sign up for CLEs like the Law Over Lunch series. But highly recommend you log into your member portal if you are not currently a member of the elder law section, and join our section today, of course, after you listen to this important ethics chat. And the link to our website is also on the slide. So without further ado, we'll move on to why you're all here today, to learn about this important ethics in estate planning and disclosure conversation.
All right, thank you, Max. So the reason that we chose to do this CLE is because recently there was a Florida Bar member that was disciplined for client service, essentially. So in summary, of course, we changed the names of the characters to Star Wars to make it more fun. So this attorney, Mr. Windu, has been practicing estate planning in Tatooine County for over 38 years. And he was a good lawyer, a good member of the community. He made a mistake. And we're going to talk about 3 clients that he had that the bar examined in their complaint and further proceedings. So the first client, Ms. Chewbacca, went to see the attorney. She brought her friend, Miss Leia, and they sought out estate planning for Miss Chewbacca. And so Mr. Windu, the attorney, said, I'll serve as successor trustee of Ms. Leia's trust. Miss Leia didn't want that. She wanted her friend, Miss Chewbacca, to serve as her successor trustee. But somehow, when drafting the documents, Miss Chewbacca, for whatever reason, Miss Chewbacca's documents, the attorney appointed himself and his law partner, also his stepson, as backup successor trustees. And when the Florida Bar investigated, the attorney said that Miss Leia requested the firm members serve as the backup successor trustee, and they agreed to do so. But as we'll discover when we go over the ethics rules, there was a violation here because no written informed consent was obtained for the attorney to act as successor trustee. The attorney thought, as many attorneys possibly would believe, that by signing the documents which contain the attorney as the successor trustee and the attorney's stepson, another attorney of the firm, by signing the documents, that's enough. It's not enough in accordance with the ethics rules.
One of the other clients that Mr. Windu had was Miss Solo. Miss Solo sought out an attorney who offered free wills for those over the age of 65 back in 2015. In 2021, she decided to revamp her estate planning documents, and upon reviewing it, she noticed that the attorney had unknowingly named himself as trustee, and again, his law partner, who was his stepson, as the successor trustee. But the attorney didn't stop naming himself in those capacities there. He also named himself as the nominated personal representative in her will, the healthcare surrogate and her designation of healthcare surrogate, her pre-need guardian, and like I said before, his partner was named as the successor to him in all of these documents, his partner who was his stepson. There was no written informed consent by Miss Solo allowing Mr. Windu to serve in any of these capacities. The third case, Heidi Brown will discuss now.
Meanwhile, across the galaxy, when the bar was investigating these complaints, they discovered another probate that implicated Mr. Windu. It was in the estate of Qui-Gon Jinn, and in the pleadings, and as in the documentation, the same attorney tried to name himself as, quote, a surrogate designated beneficiary who would take the place of the beneficiaries who were named in the will. Mr. Mace Windu drafted and filed affidavits for the beneficiaries to sign, in which they gave up all of their rights and responsibilities to the estate. And then it would allow him to be this, quote, surrogate beneficiary. Unfortunately, he failed to advise them to seek independent counsel before signing the documents, which effectively waived their rights as the beneficiaries. In this estate, the only asset was the home. And Mr. Windu said that he was going to donate the profits from the sale to the Council on Aging. Now, he did decide to handle this as a pro bono matter. And ultimately, the sale proceeds, which were about $20,000, did end up going to the proper beneficiaries and not the beneficiary that Mr. Windu would have picked. However, the bar still felt that this was not enough. It did not matter that he handled this probate pro bono.
So the results of the bar investigation, and we're still focusing on the ethics rules before we get into any statutory considerations, called for Master Windu, and thank you for indulging my Star Wars references, was suspended for the practice of law for 90 days with automatic reinstatement. And the basis of that discipline included some of the following key rules that we'll discuss in a little bit. Florida Bar Rule 4-1.7a, conflict of interest involving current clients. Sub B, conflict of interest, current clients. And 4-1.8, conflict of interest, prohibited and other transactions.
Okay, so I talked to a lot of lawyers as the co-chair of the ethics committee that just they don't come across the ethics rules. They don't read the ethics rules. They're looking for statutory and case guidelines. But I respectfully submit that that's a mistake. Really the purpose of our ethics rules are to protect the public at large and to enforce and maintain the integrity of the legal profession, which is so important to us as true professionals. And when we think of ethics rules, when we learn about them in professional responsibility in law school, and we take the MBE, I have a law clerk who's a rising 2L who's taking this next semester. I was explaining to her, it's not just about competency, promptness, and diligence, which is really, you know, how most people summarize the ethics rules. We cannot put our interests ahead of our clients. And that is the lesson here. That is the lesson of this, you know, Florida Bar investigation and resolution of this investigation. We must remain autonomous and self-governing as lawyers. And to do that, the bar strictly enforces these rules. And we're going to go through these ethics rules, and we're going to explain about how, you know, informed consent is not just a medical concept. It's a legal concept, and it's our obligation as lawyers, ethically practicing elder law attorneys, to explain these circumstances to our client and explain the alternatives. And we're going to go over that now.
So the first is Florida Bar ethics rule we're going to discuss is 4-1.7A and B. I have them both here on the slide for you to read, but you can read along with me as I read them out loud. A states representing adverse interests, except provided in Rule 4.17B, a lawyer must not represent a client if the representation of one client will be directly adverse to another client, which isn't typically implicated in estate planning, but it can be. And the second is there's a substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or the personal interest of the lawyer. And the personal interest of the lawyer is really what we see in Master Windu's cases. Now, all of these there's exceptions to these, which is found under B, which is titled informed consent. Notwithstanding the existence of a conflict or interest under subdivision A, a lawyer may represent a client if, one, the lawyer reasonably believes the lawyer will be able to provide competent and diligent representation to each affected client. And that is likely, and we don't know what Master Windu's mindset was, but he likely believed he was in a better position to represent his own client's interests as a fiduciary than their selected individuals, or no one if they had no one. But we don't know that. 2, the representation is not prohibited by law. 3, the representation does not involve the assertion of a positive adverse to another client when the lawyer represents both the client in the same proceeding before a tribunal. And 4, each affected client gives informed consent, confirmed in writing or clearly stated on the record at a hearing. Well, in estate planning, we're never going to have a hearing, so it has to be confirmed in writing. Now, what does informed consent mean? Luckily for us, the bar has given us a definition under the terminology section of the Chapter 4 ethics rules. And they say, informed consent, quote unquote, denotes the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information. And that's the key, adequate information and explanation about the material risk of reasonably available alternatives to the proposed course of conduct. So with all of that in mind, a lawyer serving as a drafting counsel will have a fiduciary self-interest if they were to appoint themselves as an agent for their client or a fiduciary for their client, because they can get fees for that representation. This impacts the lawyer's duty of loyalty to the client because the lawyer has a possibility of placing his own self-interest before that of the client or the client's wishes and desires. To avoid a potential client conflict, the conflict must be disclosed clearly and in writing as stated in 4-1.7B4, if we're going to be very specific. And the client then decides whether or not, after all of this informed, explained, and adequate information is communicated to them, whether or not they want their attorney to serve in multiple capacities, whether it be trustee, personal representative, an agent under a DPOA, or under a healthcare surrogate, or even a pre-need guardian. So if we were to apply these rules to Master Windu's matter, Should Mr. Windu name himself as a fiduciary, he must provide the client with written disclosure and an opportunity to obtain independent counsel, who would then, he would also have to explain that he's entitled to receive additional compensation, possibly in multiple capacities, which Max and Heidi will discuss later. And his course of action may be impacted by his own self-interest. However, as we stated, this conflict can be waived with proper disclosure and an explanation of everything. And if the client, after written consent, the opportunity to discuss with counsel, has time to consider all the implications of assigning and appointing or nominating their attorney as an agent or fiduciary, then they can proceed with not only listing that person in their documents, but that attorney then may have covered sufficient bases to proceed in the capacity of having multiple hats and serving their client in multiple capacities. Heather, do you want to go into the next rule?
Yes. So 4-1.7 and 4-1.8 really work together. And so the 4-1.8A, which is what was included here, talks about a business transaction with or acquiring adverse interest to client. So, in order for, an attorney and a client to enter into this business transaction, such as serving in the capacity of a personal representative, a trustee, a power of attorney, even healthcare surrogate, as Cassandra said, it has to be explained. The transaction in terms on which the lawyer acquires the interest have to be fair and reasonable to client. Can the lawyers charge more to serve as personal representative based on their expertise? Maybe they're more efficient. That has to be disclosed and transmitted in writing to the client that they understand. And that's another really important part of this rule. If you look at the comments to Rule 4-1.8, it explains that you have to explain things different based on the level of sophistication of the client and whether or not they're already represented. If you're acting as personal representative and attorney for the estate and a beneficiary is represented by counsel, it's a different conversation than if you're talking to an unrepresented beneficiary. And that's important for the lawyer to know and be able to address. The client has to have these things in writing so that they can think about it. The lawyer has to explain that they have the right to seek independent legal counsel on the transaction and make that sort of review. And then finally, the lawyer must give the client this written informed consent and give the client the opportunity to review it, understand, and then finally to sign it. Because if the lawyer is representing the client and also receiving, essentially another payment, the client ought to know that they have other options. Also, as Heidi mentioned at the beginning, that this Mr. Windu made himself a surrogate beneficiary, to be able to complete this transaction. Again, you can't do that. You can't solicit a gift. You can't, the comments go through that you can't really essentially prepare the documents naming yourself without independent review. And that's a really important point here as well, because a lawyer must disclose this conflict. And I don't think that people really think about this without reading these rules, that this is a conflict. I was the lawyer for the estate. Maybe I was the lawyer that drafted the documents. Now they're asking me to serve as personal representative. They asked me to serve. Why should I have to do another written consent? They know what I'm doing. Because you're a true professional and you must explain yourself. So the lawyer has to disclose this conflict in ways that maybe the client didn't think of. They have to talk about the terms of the transaction and the lawyer's dual role, because the client has to understand that they have other options, and they have to understand how the lawyer's self-interest impacts this transaction. Could it be done better by another individual? Could it be done less expensively by another individual? And without, just sitting there and influencing the client has to have some time to absorb this and understand and meaningfully seek out independent counsel review. They can't just say, well, no, I don't want to do it, I'll just sign. I wouldn't do it that way. Reasonably, the client needs time to absorb before they decide, okay, yes, I do want the personal representative to serve. And that's a good protection for the lawyer and for the client. It isn't acceptable for the lawyer to say, I'm the surrogate beneficiary, without giving these beneficiaries informed consent about how it could work otherwise. The comments to Rule 1.8 really talk about the alternatives, but I'm not trying to dissuade lawyers from serving, because in a lot of places, this is part and parcel of what lawyers do. I understand from a lot of lawyers that this is something that's fairly popular in smaller legal communities where maybe there's one lawyer in 20 miles. And as the comments say, a lawyer's legal skill and training, together with the relationship of trust and confidence between the lawyer and client, create the possibility of overreaching when the lawyer participates in a business, property, or financial transaction with the client. It is the first line of the comment, and it is the essence of this rule and why we need this informed consent. And I commend you if you're doing this, if you're thinking about doing this, not only do you check your malpractice insurance, but also you check the ethics rules, because Mr. Windu thought he was helping his clients. He had a relationship with them. But what the bar says is that he engaged in a pattern of conflict due to his own self-interest. This was not just a one-off. There were 3 cases here where he did this. So even if the attorney may act as a better agent than a layman, their services as a layman might be free. The attorney is going to charge a fee. So the client needs this disclosure. I see that there's a question. We're going to answer it at the end, but we'll go through it. But in essence, when you look at the comments to Rule 1.7 and 1.8, you ought to be able to see what you can do. But we can go through that more specifically if we have time at the end. Max.
Okay, so I'm going to discuss the disclosure statutes that are based on the ethics rules that Heather and Cassandra just expertly and excellently informed all of us about, and that I always learn something about when I read. And as a tip and suggestion, I recommend, because this is actually coming up in a few different cases right now that I'm actually litigating. If you have further questions besides actually calling Heather and Cassandra, which I'm sure they would love for all of us to call them randomly, you can also call the Florida Bar Ethics Hotline, and they'll point you in the right direction with suggestions for further reading and further tips. And that they have been very helpful with that for me for some of my very tricky litigated cases. So as Heather just explained, if you are going to serve in some type of a fiduciary capacity, and for purposes of today's conversation, we're only going to be talking really about serving as a personal representative, PR, and trustee, and in that attorney role. We're not talking about powers of attorney, healthcare surrogates, or other types of fiduciary roles like a guardian. Then we need to have some type of disclosure keeping in line with the ethics rule and per the probate code and trust code. So looking at the probate code first, if an attorney is going to serve as a personal representative and as the attorney, then 733.617 sub 6 says that, except as otherwise provided in this section, if the PR is a member of the Florida Bar and has rendered legal services in connection with the administration of the estate, then in addition to a fee as the personal representative, there also shall be allowed a fee for the legal services rendered. And as an aside, before continuing, I also would remind everyone about the recent change of the mandatory fee disclosure for the representing a PR that should be in everyone's engagement agreement, but that is also a topic for another day. Now, when an attorney serves as the trustee and counsel for trust administration, in the trust code 736.0708 4A, an attorney serving as a trustee or a person related to such attorney is not entitled to compensation for serving as trustee if the attorney prepared or supervised execution of the trust instrument that appointed the attorney or the person related to the attorney as trustee, unless the attorney or person appointed is related to the settlor or the attorney makes the following disclosures to the settlor before the trust is executed. Unless specifically disqualified by the terms of the trust instrument, any person, regardless of state of residence, is eligible to serve as a trustee. Any person, including an attorney who serves as a trustee, is entitled to receive reasonable compensation for serving as a trustee, and compensation payable to the trustee is in addition to an attorney fee payable to the attorney or the attorney's firm for legal services rendered to the trustee. So in the next slide, we're going to look at those two disclosures, and then Heidi and I are going to talk about those best practices for how to actually handle that in both of our respective drafting and actual real world courtroom experience practices. So in different parts of the estate, different practice areas and different experiences. So if we can go, yep, that slide. Thank you, Heather. So this is the actual statutory language that a lot of people actually don't see, because if you just Google it, or if you go into West, it's at the bottom of 733.617. But this is actually the disclosure. Now, this is the written disclaimer that your client that needs to substantially needs to sign, but this is the form that it needs to substantially appear as. And as you can see, it is clearly and explicitly saying that I, Qui-Gon Jinn or Heather Samuels, have designated my attorney, an attorney employed in the same law firm as my attorney or a person related to my attorney, as a nominated personal representative in my will or codicil dated July 19th, 2023. Before executing the will or codicil, I was informed that, subject to certain statutory limitations, most family members, regardless of their residence, and or other individuals who are residents of Florida, including friends, corporate fiduciaries, are eligible to serve as a personal representative. And so it's very explicitly stating that I understand that all of these other people could serve. It doesn't have to be the attorney. Any person, including the attorney who serves as a PR, is entitled to receive reasonable compensation for serving as a PR, as well as serving as an attorney. Compensation payable to the PR is in addition to any attorney fees payable to the attorney or their firm for legal services rendered to the personal representative. So it is very clear. It explicitly states all of the requirements that Heather and Cassandra went out and said. So it complies with the ethical guidelines. It addresses all of the problems that were addressed by the bar in the fact pattern for the problematic Star Wars case, and it's right there. Now, our firm, we do not typically serve in a PR scenario. We don't have a limited power appointment or any type of power appointment that would allow a beneficiary to name an attorney at my firm as a backup or emergency, or would give my firm the ability to name a backup PR or trustee on the trust side. But again, and we are in a rural area, somewhat rural area, I understand why this subject would come up. And I've seen it in court again on our litigation side. But if this is what you're going to do on your drafting side, you need to do it in this very clear way and make sure that your clients are clearly informed. So I think we should move on to the trust side. And on the trust side, it needs to be very clear, especially when there's less likely to be judicial oversight, judicial intervention. You have that similar type of declaration. This time I'll pick on Cassandra. Cassandra declare that I have designated my attorney an attorney employed in the same law firm as my attorney or a person related to my attorney as a trustee in my trust instrument dated X, Y, and Z. And before executing the trust, I was informed that unless specifically disqualified by the terms of the trust instrument, any person is eligible to serve as a trustee. Any person, including an attorney who serves as a trustee, is entitled to reasonable compensation for serving as trustee. And 3, compensation payable to the trustee is in addition to any attorney fees payable to the attorney or the attorney's firm for legal services rendered to the trustee. Now, when I'm looking at this from both the drafting side and from a potential, litigation side, the key phrase in this one for number 1 from a potential contest, and Cassandra, you tell me your point of view, because you do a lot more litigation than I do, but the key phrase in here is, I think, number 1, because having that in there is telling me that the settlor or grantor or trustor, depending on which language our audience is using, was not unduly influenced, was not pressured, and was not exploited, and was not forced against their will into signing the trust, and specifically was not forced into the provision of naming me as their trustee, and that they were fully informed that they could name anyone else, because maybe at our consultation, no one else knows that they said, I have no one else, I'm an only child and everyone else is dead and no one else could serve as trustee. Similar to the case study that we brought here today. So
with that in mind, there are multiple situations where perhaps someone is a widow and they never had children, or there's no nieces or nephews and they're leaving everything to charity. And they do want their attorney to serve in this capacity. Multiple of us have seen that multiple times. I think the key to all of this is says the written statement must be substantially in the following form. And so while any statement that you have your client sign should have this information, you're allowed to tailor it. And as long as there is written and informed consent that was adequately communicated and explained to the client, and the client has had an opportunity to address those issues further, I think we as practitioners are covered. You know, as a litigator, that would be hard for me to file an objection and I think overall win. But the more facts you have, the more information you have, which shows that your client knowingly consented to this, and like you said, was not unduly influenced, did have the capacity to understand. It's a contract. A contract is a contract, and we're going to abide by the contract, and the contract speaks for itself unless it's blatantly unjust and contrary to all public policy. And so again, the more information you have, the more informed consent you have written, the stronger your client's wishes are likely to be protected, and you as a practitioner are going to be protected from liability.
Thank you. And I am ready to move on. And
now we're going to talk a little bit about best practices. So your client has stated that they have no one and they would like you, they trust you to be their fiduciary for their will and trust. And so what should you do to comply with both the ethics laws and also the Florida statutes? So the first thing, and this is obvious to all of us, is you have to have fee agreements, and you need different fee agreements. You're going to need a fee agreement for the underlying estate planning work. You will need a fee agreement for the fiduciary agreeing to be the fiduciary. And you may even need a fee agreement that shows how much you are going to charge as an attorney for the personal representative, assuming that you're going to be representing yourself. And you are allowed to get fees for doing both, but you do need to have this disclosure, and you need to disclose how these fees are going to be calculated. If it's going to be a percentage, or is it going to be a flat fee, or is it going to be some hourly? There are mandatory disclosures for attorneys who represent personal representatives. For example, in Florida statute 733.6171, it does go into the mandatory disclosure that is now required as of, I believe it is 2022 was when this came into being. And you have to have this mandatory disclosure in your probate fee agreements, pretty much. And there's also one, I believe, for trustee, if you're going to be representing the trustees. So you definitely, even though you're not serving as personal representative or successor trustee right now, you do need to have this fee agreement for the future. You need to show ahead of time, not after the signing, to your estate planning client, so that they understand exactly how you're going to charge and how much it could end up being. And you also need to disclose how are you going to charge for staff if you end up using your staff. Now, I will note that if you are the actual personal representative or the actual trustee, oftentimes you aren't able to often delegate that work to the staff. If you have to call the bank, they will want to speak to you, not to your paralegal. So you have to keep that in mind if you're charging hourly, that the bill will be naturally higher because your hourly rate is probably a lot higher than your paralegal's hourly rate. So just keep that in mind. I think another thing that you always need to remember is that the old adage, pigs get fed, hogs get slaughtered. You know, is it reasonable to take I'm just making this up, a 5% fee on $1 million trust that goes on every year? Probably not. I think that's going to be shocking to the conscience. You also need to make sure that all of the necessary terms are spelled out in the fee agreement and what all this will entail. For example, are you going to have to delegate the investment function? Do you feel comfortable looking at, when the time comes, your client's portfolio of stocks and making recommendations? Or are you going to use a financial planner, such as a certified financial planner or some type of a financial advisor? Well, if you plan on delegating that out, you probably should note that in the fee agreement, because that may implicate your client's thinking on the matter. Also, do you plan on using, if the client already has their own financial advisor, do you plan on using that financial advisor? Maybe that also needs to be placed in the fiduciary agreement ahead of time. And then also, you know, perhaps you want to talk about, if you do end up serving during the life of your client, how they feel about gifting. How do they feel about living in their own home versus having to go to a facility if they need long-term care? How do they feel about taxes? Who are their normal CPAs and financial advisors, etc.? You probably should also, and we don't have this on the list, but you probably should also, if you're going to serve as PR and or trustee, you should have information about the assets that are currently in their estate or in their trust, so that when they do pass away, you have some sort of starting point to look at. And who are their trusted resources in their life? Who is their CPA? Who is their stockbroker, etc.? Another thing to think about is, I think someone's already mentioned this, check your malpractice policy to see if it covers acting as a fiduciary. If not, you may need to increase it or ask for a rider. And then you also need to think about, are you going to be representing yourself as the PR or using another attorney in your office to represent you when you're acting as PR? Or are you going to get an attorney to represent you who is outside of the office? And whichever way you decide, you need to disclose that and disclose the effect on the fees, etc. You, of course, we've already talked about informed consent. Before you, we have the definition of informed consent that shows up under the healthcare surrogacy statutes, and also one that is used in estate planning. And these definitions are very, very similar to the one that we've seen for the Florida Bar for the rules of professional conduct. So with all of these, it's coming down to, is the client able to consent voluntarily after being given an explanation and given alternatives of what naming you as fiduciary will actually mean? And does this also allow them to does this allow them to keep going with their objectives as well? And then another best practice may be to give the client copies of the statutes themselves. And what we mean are the statutes of the disclosure statutes in the Florida statutes. So that would be the 736.0708. and the 733.617 and the 733.6171, you know, give them also another copy, a separate copy of the statute, so they can read it, so that it impresses upon them the importance of all of this. Finally, you want to tell the client to go out and get a second opinion. about the practicality and the expense and the reasonableness of naming their own attorney to be fiduciary. And you also want to give them time to review these drafts before signing. You don't want to be coming up with this idea, or having your client come up with this idea the day of the signing. If that happens, I think you're going to have to tell your client, okay, we need to regroup. I'm going to give you so many days to think about it and get a second opinion. But if this idea comes up on the day of the signing, I think that will make it harder to look like it is voluntary and without coercion on your part.
And if I can just jump in quickly, I know we only have an hour to get through a lot, and I have done about a 3-hour presentation on just litigation strategies on a similar topic. But I do want to just keep in mind, and again, Cassandra, my fellow litigator here, might have a different point of view, but I recommend everything that Heidi just mentioned as the chair of the Estate Planning and Probate Committee, which meets monthly. Another reason why you should join the elder law section, which, by the way, helped to contribute to some of these statute changes that some of you are submitting questions about, that the legislature changed recently. So if you want to be on the forefront to the Florida legislature actually changing and revising the probate code and trust code, we're part of that, is to document all of this, because we have lots of estate planning clients, but if you have ADHD like I do, your memory is not going to change. And if you remember the fact pattern, one of the key things that Heather mentioned initially was when the person was trying to keep up with the Florida bar, the attorney also just couldn't remember and didn't have actually any evidence and documentation to support their position. So one of the issues with this is you need to document your interactions. And that is something that I have used and needed in when I've represented beneficiaries, or when I have just met with my estate planning clients on multiple occasions, because it is a best practice to make sure that you are, regardless of what the reason is, your client should have those drafts, the ability to review them, think about it, and then come back, ask follow-up questions, and then actually sign them. But just as a reminder, you should be documenting all of your meetings with your clients, going over those drafts, because when you're initially meeting with your clients, odds are the only person in your room, besides maybe an assistant who may come and go, may no longer be with you, may no longer be at your office, so you can't find them to testify and be a witness. It's just you and your client. And because it's estate planning, by the time this is a litigated issue, that person's dead, or has diminished capacity and can't testify. So you need to document all of these interactions.
And so while there's much more to say on the topic, we will wrap it up, excuse me, with the 2 questions that we have in our last 5 minutes. One was, do we tell the client to get a second opinion or advise the client of the right to the second opinion? Your only obligation as an attorney is to advise them of their right to get a second opinion. If you'd like, you can even provide individuals and multiple individuals who they may get their second opinion from. But ultimately, it is up to the client whether or not they want to obtain that second opinion. The second question we have is a little more complex. It says 736.0708. What does not entitled to compensation mean? Does it mean only the lawyer is not entitled to be awarded compensation by the court? Assume the beneficiaries agree, notwithstanding the statute to pay the lawyer. Is the lawyer not entitled to a fee? And does that mean it's not deductible expenses for tax purposes? I don't think any of us are going to opine as to whether or not it's a deductible expense for tax purposes, but we can take the questions as it is related to the statute. Now, 736.0708 does say that you're entitled, you should not take compensation, but there is an exception unless the settler before the trust instrument is executed is disclosed all of these matters. So just get a disclosure from your client when there is a settler. If you've already previously done estate planning documents where this disclosure was not made, reach out to your clients. This may be an excellent way to touch base, see if any other modifications need to be made. And if that's the case, it's easy to have them execute this before then. Whether or not beneficiaries agree, a court's never going to be involved in a trust administration matter unless it becomes disputed. At which case, do you want to rely on other beneficiaries saying we knew or we did not adequately know about this? That's up to you. That's a judgment call. As a litigator, I could see this going either way. Max, do you want to opine as to where this could possibly lead?
I actually think that you pretty much said what I was going to say. But
Cost risk is a thing, and
Yeah.
we're attorneys, and that's our job. It's our job to analyze for our clients, and sometimes we have to do it for ourselves.
to me, it's always the cost benefit analysis. I'm sort of the negative Nancy of the four of us. And I just think, like Heidi said, pigs get fed, hogs get slaughtered. That's actually one of my, or I was about to say bosses, but law partners. Now that's actually another motto at our firm. I personally do not see what the benefit is in putting yourself in this position. There actually is research done at the national level. If anyone's interested, I don't have it right in front of me, about the risk benefit of holding on to like original wills, because that is considered the equivalent of holding funds in your trust account. And so you have to insure it, and whether or not there is actually money in it over time, to hold on to the original will versus giving it to your client. There's also now research into things like this. I don't think it is worth the risk. The conclusion in that study says it's not, because of the malpractice insurance and other risks like that, especially in a state like ours. I personally, as a best practice option, I do not see a benefit in serving as a PR or a trustee of an item that you have also prepared and drafted for one of your clients, because of the conflict of interest and disclosure issues, but also because of the application of the law to real life. And also, like Heidi said, and I think Cassandra also touched on earlier, you need to talk to your malpractice carrier and your insurance and to see what hat you are wearing to make sure that you're covered. Because if you're talking about as a PR, 3% or whatever of even a $5 million estate may not necessarily be worth it. I'd rather represent the fiduciary. I don't want to be the fiduciary.
Right. Thanks, Max. Max, Heather, Cassandra, Heidi, thank you so much. Amazing presentation. We will have in our annual update, which I believe is going to be held in February next year, this topic is going to be more expanded on. So if you're interested, look out for emails from the elder law section about our annual update. Again, the course number is 7657. If you want to join any of their committees, Heidi and Max for the estate planning committee, or Heather or Cassandra for the ethics committee, their emails are on the screen right now and will be in the PowerPoint that's emailed out later this afternoon. I want to thank everyone for joining our Laws Over Lunch series, and we hope you will join us for our future programs. And have a happy Wednesday. Thanks.